Hey guys, well, the wait is over and we have the order in the Georgia Trump case. And of course, the judge there did not disqualify Fani Willis. And let's take a look at that and see where he departed from the analysis I had for what the standard should be. He agreed on some of it, but expanded that to some degree, although it didn't amount to anything. So I'm not sure. Well, I do have an idea why that happened. Let's take a look. All right. So here we go, talking about the basis for this thing, as everybody knows. So they say the judge says, among other allegations of disqualifying conduct, the defendants contend the district attorney attained a personal stake in the prosecution of this case by financially benefiting from her romantic relationship with Special Assistant District Attorney Wade, and she personally hired him. That was the centerpiece of the hearings. You'll see here, ultimately, that didn't amount to much as far as this order is concerned. All right. So allegedly they traveled together, which of course they did. Money going back and forth, maybe more money from him than her. That was contended, of course. The state says, hey, look, she didn't get any financial benefit from this, and that the expenses were roughly divided equally. All right. Okay. So the claims presented, as alleged, a possible financial conflict of interest for the DA. And he couldn't really figure it out unless he had an evidentiary hearing, he says. And he couldn't ignore this because it would endanger a criminally accused constitutional right to procedural due process. All right. Okay. Again, we'll see how this matters or doesn't matter shortly. 2.5 days of testimony, blah, blah, blah. But he says the defendants failed to meet their burden of proving that the district attorney acquired an actual conflict of interest in this case through her personal relationship and recurring travels with her lead prosecutor. So that's it, right? And we discussed in the past video, which he doesn't dispute, as you'll see here, that if you have an actual conflict of interest, one of the couple of grounds to disqualify a prosecuting attorney, you're gone from the case. The DA is gone from the case. He says, well, that didn't happen here. There is no actual conflict of interest. Okay. Even though he's going to order them to change their behavior later, based merely on the appearance of it, it's not an actual conflict of interest. Okay, he says that they have not carried that burden. Forensic misconduct, the other ground for disqualification, also denied. He says the record highlights a significant appearance of impropriety that infects the current structure of the prosecution team, and it's got to be removed. So that was a big discussion. I got a lot of questions from that on when I said, hey, look, it requires an actual conflict of interest as the way I read the cases. And then if you have that, the appearance of impropriety that arises from that means you're automatically booted off. You don't have to show harm if you have a conflict. Well, the judge does say that he thinks you can boot somebody off for appearance of impropriety, as we'll see, but that's not an automatic thing. It's instead of a real conflict where, okay, here's a conflict, you're gone, that he thinks he also has the power to boot the DA off just for an appearance of impropriety, but he doesn't do it. So it didn't amount to much. So it was more academic discussion, I think, than mostly anything, but it was really oriented to getting rid of the boyfriend conflict here. So he talks about actual conflict. The highest standard that prosecutors are supposed to be held to. They can strike hard blows, but never foul ones. And they're beyond mere advocates for one side. They must make decisions in the public's interest, not their own personal or political interest. They're not empty slogans, okay? And the court can step in and disqualify a state prosecutor, especially when that prosecutor labors under an actual conflict of interest. Yeah, they're supposed to do it then. Again, if there's an actual conflict, then the DA gets booted, right? So he doesn't find that here. He doesn't find either of the two mandatory reasons why DA would be booted out, and doesn't boot out the DA. All right. Talks a little bit more about stuff free of temptation and suspicion. A lot of nice language there. Okay. The criminal law should be above suspicion. Does it get there with this order? No. I mean, if you thought this stuff amounted to anything, I don't think it's cured by what he does. If you didn't think that, then you may be okay with a solution, which is just to get rid of Wade. All right. This Georgia Supreme Court has recently denoted conflicts of interest and forensic misconduct as the two generally recognized grounds for disqualification. Conflict of interest. But then he does say he reads the cases to expand that to not just a conflict of interest, but an appearance of impropriety, which isn't a conflict of interest. Okay. And I get what he's saying, but again, he thinks that gives him discretionary authority to remove somebody rather than a mandatory um, outcome like you would have if you have an actual conflict. So, all right. Personal interest or stake in a defendant's conviction, that's a real conflict of interest. Everybody agrees about that based on the case law. In such circumstances, no showing of prejudice by a defendant is required, right? And so, in other words, you don't have to show that the DA actually did anything bad to you because of this conflict. If you have a conflict, the person should be gone. All right. Remain unconflicted. But whether there is a conflict is a fact-driven determination. And there's a lot of things that aren't conflicts. So finding insufficient evidence of a conflict after establishing the attenuated nature of the connection between lead prosecutor and victim's mother, who worked as an employee at the same office. Now, here's interesting thing here. Wade's manner of payment is not actionable on its own. Whether a private attorney like Wade is paid by the billable hour or whenever, a motive exists to extend the case. Yeah, of course, you're making money. You want to make more money. That's why you're trying to make money. So that makes sense. But that's not a conflict. Then he says, nor would a romantic relationship be between prosecutors standing alone be enough. That's not enough either. It's when you put the two together here that there's a prima facie argument of financial enrichment and improper motivations, which led to this motion. So that's the appearance of impropriety. And so he says that's not a real conflict, and none of the stuff she said or any of those things in conjunction with this creates an actual conflict of interest. It just looks bad, he says. Now, again, I feel like the cases do not support throwing DAs off for just looking bad, but he more or less does. But of course, here he does not throw her off. So there you go. As to the financial allegations, the court makes the following findings. She hired him, yada, yada. He wasn't paid that much, relatively low amount of $2.50 an hour. It's not quite as low, though, when you have the ability to just charge it all day to one client. As any attorney knows, that's a lot easier than charging several clients and try and juggle a bunch of cases. But whatever, it's his factual determination. And he wasn't supposed to charge more than 60 hours per month without permission. They went on trips together. Everybody knows it. Here's a scroll through all of that. All the Travelocity they did, and they went dining out. They exchanged. Sometimes one paid, sometimes the other paid. So potentially, she could have gotten $12,000 to $15,000 off of this. But they say they weren't supposed to be gifts or whatever. And then anyway, she was reimbursing him in cash and also paying some of the things herself. So that might have meant that she either came out roughly even, as they claim, or just slightly ahead. And we'll get through this. As the best guesstimate was all they could do. There's no ledger here, of course. But the district attorney may well have received a net benefit of several $100s. And of course, we know that's not going to be enough to taint somebody on the case in and of itself here. So he says, if that's the conclusion he gets to, which it is, the court finds the evidence did not establish the DA's receipt of a material financial benefit as a result of her decision to hire and engage in a romantic relationship with Wade. The defendants have not presented sufficient evidence indicating the expenses were not roughly equal, more or less, and therefore that Willis was greatly interested in the prosecution for money. And I don't think that while she may have gotten more or less money than what was said, she was going to be prosecuted in this case, whether her boyfriend was on it or not. That's not really the point, though, is it? The point was she getting money off of it, is what the defendants were trying to say. And that creates this conflict, or the appearance, which once you go down the appearance rabbit hole, you're going to find out you don't really win. All right. The court, blah, blah, blah. So the court says that the money that she may have gotten from Wade was not a motivating factor on the part of her to indict and prosecute this case. And that's true. You're going to find out that's true because he's already resigned. She's not going to stop pursuing this case, and she didn't initiate it so that she could get money. Okay, I think did make that point in the other video, that whether she went on a trip with him or not, she was going to be doing this case. They didn't create this case for money. That was a side thing to the degree it existed. And that she made plenty of money, especially in relation to what she might have gotten from Wade. And that this is interesting here. The defendants failed to demonstrate that the district attorney's conduct has impacted or influenced the case to the defendant's detriment. Again, if this were an actual conflict of interest, they wouldn't have to do it. But he says, well, if I'm going to float down the river to this appearance of impropriety, you're going to need to show me some stuff. And you didn't do it, he says. Oh, well, in fact, he confirms what I just said. While prejudice is not a required element for disqualification, it's relevant to considerations of due process and the defendant's requested remedy of complete dismissal. Yeah. Depends on what your findings are, the nature of the conduct, whether it's an element or not, right? So if it's an actual conflict, you don't have to have it. But anyway, they say that the idea that they would prolong this case in order to make more money is not supported by the evidence, that she wanted to get this case to trial quickly. Yeah. I don't think that the money means that she created this case for money and then wants to prolong it for money. Whatever she's at least not through getting it from Wade, right? If she's going to make bigger money on this case, it'll come when it's over. That's not being discussed here. Okay. Just the money that she was allegedly potentially getting from Wade. Okay. The district attorney has not in any way acted in conformance with the theory that she arranged a financial scheme to enrich herself by extending the duration of the prosecution. And I can agree with that. Okay. So that means, he says, he concludes she did not acquire a personal stake in the prosecution and that money didn't impact the case. So the defendant's claim of an actual conflict must be denied. Yeah. I think he already thought this, and he reasoned to this, because if you thought it was a conflict, you could make that argument the other direction, but he just doesn't. And he's the judge. This doesn't mean the court condones the tremendous lapse in judgment or unprofessional manner of her testimony. But he says Georgia law doesn't permit the finding of an actual conflict, simply for making bad choices. Yeah, if you make bad choices, maybe you sped to the office and got a ticket, that's not a conflict. So that floating around in the ether and without being shown to the prejudice of the defendants, he said it's not a conflict. So he must confine himself to the relevant issues in applicable law. The General Assembly, the Ethics Commission, the State Bar, all these people, voters and stuff, they can do something about it if they want to, but that's not an issue for him in determining whether there was an actual conflict. And I agree there. I mean, he should apply the law, not what anybody feels about it, but he should look at the facts and decide whether there's an actual conflict. Having decided there isn't one, that's out the window. Then he goes to what he calls appearance of impropriety, where he thinks that relates to conflicts and you can potentially kick somebody out for that. And so he's got some case law support for that. Appellate courts have endorsed the application of an appearance of impropriety standard to state prosecutors, which is interesting because I think sometimes the conduct of things is an actual conflict, like a close personal relationship with a victim may be grounds for disqualification of a prosecutor. And the contingency fee arrangement, close personal relationship with the victim. In that case, the individual prosecutor who has the conflict may be disqualified, even though they just talked about it being an appearance. So this is, like I said before, this is a little murky. And he drives right through the murk there to create a clear, what he sees as a clear ability to act for appearance of impropriety, which would be good news if he were going to do it, if you're on the Trump side, but he does not. All right. So he says that you don't have to have an actual conflict to have a disqualification. All right. But the state says the facts presented suggested as much. He disagrees with the state's analysis of the case, which means he disagrees with the way I analyze this particular thing. And that's okay. It's undefined in Georgia precedent, but an appearance of impropriety is conduct or status that would lead a reasonable person to think the actor is behaving or will be inclined to behave inappropriately or wrongfully. Interesting that it's not defined in their precedent, but an actual conflict has been defined. Quit beating that drum. And he's borrowing from federal judicial recusal standards. Basically saying a social media whack job isn't the person you should think of when you're thinking about an appearance of impropriety. A casual, uninformed, or misinformed observer might believe the DA must recuse herself because her father shares the last name of the co-defendant or something dumb like that, or hypersensitive or unduly suspicious. Yeah. So that's a lot of people that comment on things. Um, all right. So you're supposed to be a reasonable person looking at it and go, oh, that shouldn't be happening. So he says the appearance standard says that when there's no real conflict, a perceived conflict in the reasonable eyes of the public threatens confidence in the legal system itself. And the one of the issues about delving down that is what he ends up doing with this is just saying, hey, why don't you just take weight off the case? That does, for all the people that were skeptical about this, I'm not sure how many people go, well, that doesn't. Okay, all the issues I had with Fani Willis really were resolved as long as I know that her boyfriend's off the case going forward. And that was not the point of bringing this motion, that the money from Wade was only one aspect of the defendant's argument that she had an actual conflict, right? So taking him off the case doesn't change, I think, the public opinion one way or the other. The people who thought she were fine, that she was acting appropriately, they're still going to think that. And the people who thought that she's conflicted are generally still going to think that, even if Wade is gone, like he apparently is now. More language about how important it is to have a judicial proceeding that people can have confidence in. Sometimes you must stand aside for the sake of public confidence in the probity of the administration of justice. All right. And he must consider this. So that's a lot there for the ultimate result in this thing. A lot. Okay. As you're going to see, the remedy can vary, he says. So when we're talking about the appearance of impropriety, we're no longer talking about the two primary methods of disqualifying a district attorney. Now we're talking about something that if it occurs, you craft a special remedy for it. And there he says, unlike an actual conflict, the finding of an appearance does not automatically demand disqualification. So if you had forensic misconduct that affects the defendant adversely or an actual conflict and you don't have to show harm, the DA is gone. But under this appearance thing, you just look at it and decide whatever you need to do is what you feel like you can do, and you do it under basically the court's general power, which it certainly generally does have that. And they looked at civil cases, which know about that. It should rarely occur, the Supreme Court says, when there's no actual trial of the case, that the actual trial will be tainted. So if you're taking the court's ruling here that the money from Wade is basically not material to Willis, all right, that's what he said, right? And that she hasn't done anything in the case based on this money. She didn't bring the case because of it. She didn't arrange this money situation because of it. She's not stringing the case out because of it. Why would you think that if they kept going like they are, that this would be tainted? Because he's going to switch gears here in a second, right? So he basically, in defending that he didn't find a conflict, he says the money hasn't motivated anything that she's done. And, there's nothing wrong with it in that sense. It hasn't created any harm. So if it hasn't done that, it's not, this isn't an untested conflict out there, right? They've been handling this case for a while, and the judge is able to assess whether the DA has done anything bad based on this money. And he says she hasn't, yet now he's going to still say, you got to throw this guy off the case. Why, if it's so good? But on the other hand, if it's so bad, maybe there was a conflict. That's why I don't like this kind of analysis, but it's just my opinion. When there's no claim the trial be tainted, appearance of impropriety is simply too slender a reed on which to rest a disqualification order, except in the rarest cases. So here you actually had days of testimony, and you allegedly decide nothing bad has happened in the case. Then why do you think something bad is going to happen in the future? So now you're dipping into the prosecution team on something that and telling them what to do based on something that you said really hasn't really hurt the defendants any. Maybe I'm the only one who thinks the logic is not complete there. Now, here he goes to where he wants to end up with this. It's noted the appearance of impropriety could be cured through screening the affected prosecutor from participation in the case. So here's, unlike a real conflict, the appearance can be cured just by stop looking so bad, stop having this appearance. So to ensure that no conflict of interest or appearance might develop, they took the prudent step of taking this person off the case. And the trial court can do different things to take care of the appearance of impropriety. And here he says, the finding of an appearance of impropriety on the part of the district attorney, in contrast to an actual conflict, it doesn't necessarily result in a disqualification of the entire district attorney's office. Although you're going to see his order is you have to go, your whole office does if Wade doesn't. Why not just her? And then what you're saying here. So I think maybe 2 weeks wasn't enough to iron out every detail on this, but that would just maybe also be the way I see it. So here he's talking about a case where the actual district attorney was disqualified due to a personal conflict. So assistant district attorneys appointed by that one lacked any authority to proceed in the case of a absolute disqualification. But the case did not address an appearance standard and made a point to limit itself to the total disqualification in instances of absolute disqualification. So the office goes out if there's an absolute disqualification. When the appearance of a conflict exists, only the affected prosecutor, be they elected or appointed, is affected. But then later he's going to say if you don't get rid of Wade, your whole office has to go. All right. Not all other prosecutors have to go, he again says. All right. So then he says there is an appearance of impropriety here. And I mean, it does look bad that she has her boyfriend and she's paying him money and stuff, but that's not particular to these defendants. You shouldn't be doing that in any case. That's any case. Now, it would affect these defendants, of course, but it would affect any defendant in any case that it occurs in potentially in terms of not being a good thing to be doing. So, yeah, it's generally bad. I agree with that. Because specific conduct. Now he says this is more than merely nebulous. So he's kind of drifting back into it's real kind of a thing. She kept on doing it. They shouldn't have kept on doing it. There's the possibility and appearance that the DA benefited non-materially from a contract whose award lay solely within her purview in policing. So all this time and all these things uncovered, you're saying it didn't amount to anything. It's, nothing bad really happened. Well, why can't they just promise, that they'll keep a ledger going forward? He doesn't give them that option, which, if it's been so innocent, why not? But he says that, well, if I did let it go forward, these concerns would persist because their relationship is stronger than ever. And then gets into unpersuasive explanation, he calls Wade's testimony. Yeah. Reasonable members of the public could easily be left to wonder whether the financial exchanges have continued resulting in some form of benefit to the DA or whether the romantic relationship has resumed, he says. So it hasn't been really that bad so far. It hasn't really done anything bad, but maybe it'll keep on going, not doing bad things. And so we shouldn't be able to have it. Okay. All right. So that she's not exercising her judgment totally free of compromising influences. But again, according to this order, at least as I hear it, she has been able to do that according to this order. She hasn't done anything in a case that has to do with this money. So why should anybody, if the money has been so good so far, suspect that it would suddenly turn bad later? I mean, I kind of feel like it was bad to be doing it. It wasn't okay to be doing it. But, that's how I see it. And they knew that. That's why they gave the testimony that they did. Defendant's focus pivoted from financial concerns to disproving testimony of the DA. The court disregards Terrence Bradley, takes no stock in it. Inconsistencies, demeanor, generally non-responsive answers left far too brittle a foundation upon which to build any conclusions. And then Robin Yurti lacked context and detail. The cell phone testimony, neither side was able to conclusively establish when the relationship evolved into a romantic one, but the odor of mendacity remains. Oh, okay. So this kind of non-bad thing they were doing caused all these people to come into court and testify in a way that maybe you can't trust. Do you do that when you don't have a conflict? Do you need to be doing that? And isn't doing that essentially the development of a conflict? I just don't like where this ended up. I felt like you should do it or not do it, but whatever. Reasonable questions about the DA and her hand-selected lead, a district attorney, assistant district attorney, whether they testified untruthfully about timing of their relationship, underpins the finding of an appearance of impropriety and the need to make proportional efforts to cure it. So if there are reasonable questions about whether she was untruthful, that's what he says here, you have the DA on the case potentially being untruthful to you in court. If you find that the DA is telling you falsehoods in testimony that has to do with this case, how can that DA stay on the case? How does that work? I think here there was a dodge a little bit that I mean, what are we doing here? Like she can hypothetically lie to you in testimony, and you're like, well, that's okay though. She can stay on the case though, because she does get to stay on the case. So why leave it out there that reasonable questions about her being untruthful, that would continue? Guess what? If people watched her on the stand and believed, according to him, reasonably, that she may have been lying on the stand, why would you trust anything else that she does in this case? She has a duty not to lie in court and sworn under oath. So again, I'm not saying you have to buy that, but if you do, and he's the one putting it in his order, how could she be trusted at any point after that for purposes of this case, or maybe any case? Right? I mean, you just got to bite the bullet. If you're under oath, you're supposed to come in and tell the truth. And he's saying, well, reasonable people could think she was lying. So his solution is not to remove the liar, it's to remove the thing they're lying about. Is that the right way to handle it? I know he's trying to do the right thing here, but I think reasonable people could also say that's not how you solve the problem of a liar. You take the liar out of the situation. Whatever. Dismissal of the indictment is not the appropriate remedy. That's generally going to be true here. Got that. He says there's not been a showing that the defendant's due process rights have been violated or the issues involve prejudice the defendants in any way. And that, that certainly is important. On the other hand, if you have a district attorney that you say as the judge, there's a reasonable position that she's lying on the stand, it seems kind of bad for defendants, maybe, when you got a DA who would be willing to lie in order to stay on your case and prosecute you. That doesn't seem bad. I know if you hate Trump, you're going to go, no, that's fine. I mean, a DA should be able to lie in order to stay on a case because we got to get Trump. But can you think beyond just Trump here and think, well, maybe they should have just put a different team in place here. And if the indictment's valid, go forward with people who haven't gotten themselves cornered like this. That's one way to think about it. All right. He doesn't want to disqualify a constitutional officer when there's a less drastic and sufficiently remedial option available. I think it's sufficient to him, and he's the judge, so he's the most important. But when he goes referring to what the reasonable person in the public can think, I don't know that leaving somebody on the case that you say who is an officer of the court, who there are reasonable questions as to whether they're untruthful about testimony involving this case, that's going to allay people's concerns. So he does say, and here's the end of it, that she may step aside along with the whole of her office. Although remember, it was only going to, the appearance would only bother her, and refer it to the prosecuting attorney's counsel for reassignment, or he can go, which I believe he has done, and the public can move forward without his presence and distracting and potentially compromising. Yeah. Okay. So again, we're going to remove the thing that allegedly was being lied about and allegedly was affecting this case, and not deal with the primary person who had it in motion. So now, again, if you don't think that she did anything wrong, and you don't think she lied, then she should definitely be staying on the case if that's the factual conclusion. But if the factual conclusion is they were engaging in behavior that he cannot allow to continue, and that a reasonable person could think that she lied about it, we don't have a conflict of forensic misconduct here. I personally disagree with that analysis, and I'm not really wedded to caring who's prosecuting the case one way or the other. I just see that as leaving this as open as it was before the order, just that Wade's gone. And maybe that tamps down some of the talk about this case. Maybe it doesn't. He's the judge, not me. So gets into forensic misconduct, talking about the expression by the prosecuting attorney on the personal belief in the defendant's guilt. We already went over that. He's going to say that didn't really happen here, though. He says it's not been decided as some showing of prejudice is required. Yeah, I thought it was. I feel like it's not. You can't just be up in the ether. You need to show that it affects you. But I think he does come down on the side that it didn't. The defendants have exhaustively documented every public comment by the DA, and some have already been addressed. Public comments about the need for and importance of the investigation fall far short of the type of bias, explicit or implicit, that must be found. Yeah, that part I agree with. Conviction rates, personal behind the scenes anecdotes, they're not disqualifying, it says. And in the unorthodox decision to make on the record comments to authors of a book. Not enough. But they may have ancillary prejudicial effects yet to be realized. In other words, this could come back to haunt them, he's basically saying. But at least at current, they don't rise to the level of disqualification. But it can't so easily be said about her prepared speech before the congregation of the local Atlanta church. It can't so easily be said, but it is going to be said because he's not going to do anything with this. So this is when, she was saying that, why are they attacking me? And it's racist and all of that stuff. But it wasn't aimed at the defendants in this case. Maybe so, maybe not. He says of the state's argument. And therein lies the danger of public comment by a prosecuting attorney. Left open to the public consider. So court finds, after considering the statement as a whole, under all the circumstances, it's okay. So, he says it does affect the defendants, or did include the defendants. Let's get to the part where he says it's basically okay, because it goes into the race card, doesn't mention them by name. So here's the situation. It didn't disclose sensitive or confidential evidence. Didn't address the merits of the indicted offenses. The case is too far removed from jury selection to establish a permanent taint of the jury pool. And that was one of the things I'd worried about before. And when you talk about forensic misconduct, you generally do need to show some kind of harm, according to the cases that I read. Maybe I didn't read them all. Nevertheless, when it's early in the case like this, as the state pointed out, you can have a jury voir dire, find out whether they even heard these comments or not, or read this book or not. So can you really show right now that there's been a prejudice work to the defendants for purposes of this case? And he says that. He says, I can't find that this crossed the line where the defendants have been denied the opportunity for a fundamentally fair trial. But think about the cumulative impact of this. So he is basically saying, in fact, he does say it was still legally improper. So legally improper comments, behavior that they can't possibly continue, and didn't tell the truth on the stand while being sworn under oath. Is it okay if witnesses don't tell the truth? This prosecutor is going to show up in court and question witnesses under oath and potentially seek charges against them if they lie. And he's saying a reasonable person could think that she lied. That's strange. The cumulative effect of all those things is no conflict and no forensic misconduct. But it may be time to prevent the state from mentioning the case in any public forum. But that's not the motion presently before the court. So he denies that and talks about all the other grounds, because there are various different things that people have argued about this. Some of them may have some merit in other forms. Blah, blah, blah. One of the defendants, or one of the attorneys, the defendant says they have the right to call the district attorney as a witness at trial to examine bias toward the defendants. It's politically motivated prosecution. Selective prosecution, blah, blah, blah. So he's saying that's a different kind of situation than what we're talking about here. No foundation for it, etc. Whether this case ends in convictions, acquittals, or something in between, the result should be one that instills confidence in the process. A reasonable observer, unburdened by partisan blinders, should believe the law is impartially applied, as those accused of crimes had a fair opportunity to present their defenses, and any verdict was based on our criminal justice system's best efforts at ascertaining the truth. And again, I got nothing personal against Fani Willis or Fani Willis or Wade or any of the other stuff. But I have to say, if you're in a situation where the judge is saying, yeah, I can't say that you told me the truth in court when you swore under oath in this very case. You engaged in behavior that was wrong and things that were legally improper. But I'm going to leave you on the case, though. I don't know that really is going to have a reasonable observer saying that's the best effort. It's maybe an effort at ascertaining the truth. Is that the best effort? Why is it so terrible to think of having a prosecutor on the case who wasn't entangled with somebody romantically and financially, hasn't made a bunch of speeches about the case, and hasn't potentially given false testimony? That might be the best effort at ascertaining the truth, but this is an effort. Any distractions from these goals should be proportionally addressed. And that's what he did. So he says that she can go with their whole office, or he can go, and he has gone. So, all right. So that's some analysis of this. It's an interesting, it is complicated topic. I did mention that before. I think it is. I think the law is somewhat murky on it. My logic is certainly different than the judges here in some respects. That's Not to say that he needed to necessarily come to one decision or the other. I just think it's interesting that with some of the factual determinations he made, how he then proceeded with his decision. But, that's, again, just my opinion. But let's talk about appeal for a minute. Are they going to appeal? Who's going to appeal? And what about cases before conviction and after conviction? So as I discussed before, some of the cases involve motions made before conviction, but most of the cases you're going to see at the appellate level are for after a conviction, because you cannot normally appeal a case for an interlocutory order. That's one before disposition of the case, unless he certifies it for immediate appeal and a higher court agrees to take it up, or maybe some rare case on a writ or something like that. So it isn't normal for a case to have a motion to disqualify, be denied, and then go to the court in the middle of the trial and get decided. That's not the normal process. So pretty much the cases you do see are going to be after conviction. And that might be the case here. Now, he may certify this if defendants want to appeal this, and then a higher court could decide to take it or not. And then that could be the exception to the general rule that it gets handled after conviction. But if he doesn't certify it, and the higher court doesn't take it, or take it under special circumstances, then a case will proceed at this point, because Wade has resigned off of it, from what I understand. So that is the whole thing about it that I can tell you. Talk to you later. Thanks. Bye.